Hello, I'm Liz Bars, Deputy Director of the Maureen and Mike Mansfield Center. Welcome to this Mansfield Dialogue, our community education program providing public access to notable speakers discussing important international and civics issues. This evening's dialogue features Professor Stephen Vladeck discussing executive power and its limits. The nonpartisan Mansfield Center advances ethical leadership, civic responsibility, and international understanding. Values essential to strengthening American democracy, leadership, and national security. Rooted in the legacy of Mike and Maureen Mansfield, our dialogues work to foster civil exchanges of ideas from diverse viewpoints, reinforce the importance of democratic institutions, and examine the role that ethical values play in public life. I am honored now to introduce our speaker this evening. Stephen I. Vladeck is a professor of law at the Georgetown University Law Center and a nationally recognized expert on the federal courts, the Supreme Court, national security law, and military justice. Professor Vladeck graduated from Yale Law School in 2004, where he was executive editor of the Yale Law Journal. He is author of the New York Times best-selling book, The Shadow Docket: How the Supreme Court Uses Stealth Rulings to Amass Power and Undermine the Republic, which has won numerous accolades and awards. He is CNN's Supreme Court analyst and editor and author of One First, a popular weekly newsletter about the Supreme Court. He also co-authors Aspen Publishers' leading national security law and counterterrorism law casebooks. In addition, Stephen Vladeck is a highly regarded appellate advocate, having argued before the U.S. Supreme Court and numerous lower federal, civilian, and military courts. Our speaker will take questions from the audience following his presentation, so please post your questions in the Q&A box this evening. Professor Vladeck, welcome.
Thanks, Liz. It's great to be with you and everyone who's joining us tonight. So I guess I'll just dive on in. The topic that we had picked for tonight was to talk about executive power and its guardrails. And I think probably spend about half an hour giving a bit of an overview and introduction, and then hopefully we can throw it open to questions. It might be helpful when thinking about executive power to start by breaking executive power into three categories. And I think we often conflate these distinctions. I think sometimes we talk about one when we mean the other. So the first kind of executive power, the most common kind of executive power that the president exercises under the U.S. Constitution is power that has been delegated to him by statute. So Congress passes statutes. Those statutes delegate authority to the president. The president, in turn, decides how to use that authority under something called the Take Care Clause, that the president take care that the laws be faithfully executed. And just to give us a contemporary example of this, whatever one thinks about the president's immigration enforcement priorities, that's an area where all the president is doing is enforcing statutory delegations. There's no, at least historical argument that the president has constitutional power on his own there. Why does that matter? Because a lot of times when we're talking about executive power in the form of statutory delegations, the real fight is not over the scope of presidential authority. The real fight is over the meaning of the statute. And so with regard to some of President Trump's immigration programs, with regard to President Biden's student loan debt forgiveness program, et cetera, a lot of the, I think, superficial public discourse might pitch these in constitutional terms, but really they were about whether the president was lawfully, validly interpreting statutes. And indeed, in the sort of mine run of cases, that's the executive power we're talking about. The second category of executive power is what we might call inherent constitutional power. This is power the president claims to derive directly from the Constitution to act unilaterally when Congress has not, basically to act unless and until Congress has acted to delegate power or to restrict it. And so a very common example of Article 2 power is the president's power to use military force in self-defense. This is actually an argument that the Trump administration has made, for example, with regard to all of the military operations they're carrying out against alleged drug trafficking boats on the high seas. You also see these kinds of arguments when it comes to diplomatic recognition, the president deciding which governments he is or is not going to recognize, and the like. The third category, and I think this is where things get most controversial, is what is sometimes called preclusive or other times indefeasible executive power. This is also an argument based upon Article 2 of the Constitution. But unlike inherent power claims, where all the president is saying is that he's allowed to act until and unless Congress has provided otherwise, arguments about preclusive and or indefeasible executive power are arguments that the president can act no matter what, and indeed that the president can act even in the face of statutes that say he cannot, or of statutes that impose limits on the actions he otherwise wishes to take. And here we have a number of contemporary examples, from the justification the Trump administration has proffered for the use of military force in Venezuela to arrest President Nicolas Maduro, to the extent to which the current administration has claimed the authority to refuse to spend mandatory congressional appropriations, to the president's claimed authority to fire heads of federal agencies, even when Congress has protected those individuals from being fired except for cause. All of these flashpoints, all of these recent examples fall into this last category. Which has historically been the most controversial, and really I think is in some respects the most troubling because it is in many respects limitless. If the president is not required to even abide by statutes, what is he required to abide by? So that's, I think, a helpful taxonomy or typology to start our conversation tonight, that really we should be careful to distinguish between whether we're talking about power that a president is exercising pursuant to statute, power he's exercising pursuant to a claim of unilateral inherent authority, or power the president is exercising in the face of statutory restrictions because he argues that those statutes are unconstitutional. And I'll try to sort of work these in as we go through some historical examples. So let me take a few minutes to talk about how executive power has evolved, at least in very rough terms, over American history. The first thing to say, and I think this is probably not going to be an especially controversial observation, at least up to the U.S. Civil War, we really saw very few claims by presidents of the powers to act alone, whether without Congress or in the face of Congress. That really much, if not most, of the executive power that was wielded by every president from George Washington to James Buchanan was power that Congress had delegated. And this was true no matter the subject matter. So when President Washington had to use troops to put down the Whiskey Rebellion in 1794, he carried into force a statute that Congress had enacted in 1792. He focused on exactly what the statute said. He followed the statutory requirements to the letter, and it was all an exercise of delegated statutory power, even though it was the military. Ditto, the War of 1812, President Madison goes to war with Congress's declaration. Congress says, yes, you can go to war. Congress says, we're at war with Great Britain. Even more limited military conflicts of the antebellum era were invariably authorized in some respect by Congress, so that we didn't really have a lot of fleshing out of claims of executive authority during this time period. Really, the only major example of a striking claim of executive power during the antebellum era is President Jefferson, which might be a bit of a surprise, who unilaterally agreed to the Louisiana Purchase, the massive expansion of U.S. territory, albeit an expansion that was later ratified by Congress. So what this means is that we really don't have a lot of good precedents for the limits on executive power from before the Civil War. For some fairly obvious reasons, and I think we don't have to dwell too long on what they were, the Civil War directly expands both claims of executive power by the president, in that case President Lincoln, and concerns about abuses of executive power by the president. The Civil War is in many respects a war that is fought on a combination of statutory and constitutional foundations. So President Lincoln claims the authority to use force in response to the attack on Fort Sumter and then other hostilities against the United States based on a combination of statutes Congress had passed and on the president's inherent Article II power to protect the country. President Lincoln actually never got to a point where he argued for that third category, for the indefeasible category. He was focused on the first two. But actually, things really only ramp up in the aftermath of the Civil War, and especially during Reconstruction, at the height of the serious, extreme separation of powers conflict between Congress, which was dominated by radical Republicans, and President Andrew Johnson. One of the really striking things we see in the 1860s, a time period I think we don't spend enough time talking about, even in contemporary legal circles, is Congress attempting to use every iota of its authority to basically set the nation's agenda, to rein in a president it disagreed with, to limit the president's power to act on his own. And the two examples that I think provoked perhaps the most separation of powers pushback were first an attempt by Congress in 1867 to literally change who the commander-in-chief of the military was. So under Article II of the Constitution, the president is commander-in-chief of the armed forces. Congress was so mad at Andrew Johnson in 1867 that it passed a statute purporting to make Ulysses S. Grant the commander-in-chief of the armed forces. That did not really fly. Congress also passed a statute called the Tenure of Office Act that attempted to insulate cabinet officers, including Secretary of War Edwin Stanton, from being fired by President Johnson. President Johnson fired Stanton anyway. That helped to precipitate his impeachment. But actually, the Supreme Court, about 40 years later, would suggest that that statute too was unconstitutional. So we have really in Reconstruction, more than in the Civil War itself, the first inklings that the Supreme Court is willing to endorse broader theories of executive power, some lines not even Congress can cross, some really powerful fonts of authority that presidents can rely upon. But these two are largely underdeveloped from the Civil War really all the way up to World War II. Again, for most of that time period, presidents are starting to act alone a bit more, but seldom in defiance of statutes, and even less often claiming that they have the power to do so. So again, when we think about executive power, say at the beginning of the 20th century, we really have just these two big categories: the president enforcing statutes Congress has passed, and maybe in a handful of cases, the president acting on his own because Congress hasn't said anything to cover the field. And perhaps the foreign and diplomatic relations, I think, was probably the area where you saw that second category the most. Okay, then we get to World War II. And World War II, of course, is very much a statutory conflict. Congress declares war against Germany, against Japan. Actually, if you want a really good trivia question to stump all of your friends, you can ask them to identify the last country against which Congress declared war. I'll give you 3 seconds to shout it out loud. And I'm going to tell you the answer is Romania in 1942. But one of the things about World War II is that World War II also helped to precipitate the rise of what we might think of as the national security state, the modern intelligence community, the centralization of the armed forces, the creation of the Department of Defense, which comes right on the heels of World War II. And with all of that comes the rise of a new class of arguments about executive power. And these arguments all invariably involved claims that the president had the inherent and sometimes preclusive power to act in defense of the nation, even if it's not an imminent attack, and to protect national security. Just to give you one very, very visible example, when President Harry Truman in 1947 promulgates the very first executive order regarding the classification of national security information, he's doing that with very, very little statutory support. He is doing that mostly on his own. And so we already had, before World War II, the rise of what we might think of as the modern administrative state, the birth of a whole bunch of federal agencies as the federal government got larger. But that was all in the statutory space. It's Congress that stood up these cabinet departments. It's Congress that created these agencies and gave them things to do. It's really the post-World War II rise of the Cold War national security state that sees the real uptick in broader claims about the president's inherent and sometimes preclusive powers beyond the limited context we had seen it previously. And so if we're going to sort of subdivide, I realize that I said 3 time periods. Well, if we subdivide the post-World War II era, we might say the first part of it was 1945 to 2001. And this is an era where we see sort of small attempts by presidents to carve out Article II powers for themselves, some efforts to engage in unilateral war making, especially if the conflicts were limited, but also pushback, for example, during Vietnam, where the efforts by first President Johnson and then President Nixon to radically expand the conflict beyond anything Congress had ever authorized engenders a heck of a lot of sort of retreat and retrenchment on Capitol Hill. Congress passes a statute called the War Powers Resolution in 1973, designed to rein in unilateral presidential war making. Congress passes a statute called the National Emergencies Act in 1976, designed to rein in the president's power to declare national emergencies as a way of triggering other authorities. Indeed, the post-Watergate era is rife with examples of statutes Congress passed to try to basically reclaim power that it had felt was drifting to the president. So war powers is an example, national emergencies. Congress passes a statute that hasn't gotten a lot of attention until the last 12 months and 2 weeks, called the Impoundment Control Act of 1974. This is meant to limit the president's power to refuse to spend appropriated money. Congress passes a statute called the Ethics in Government Act of 1978, which is designed to impose more limits on what executive branch employees can and can't do and more accountability for circumstances in which it's feared that executive officers have broken the law. And frankly, the list goes on. I mean, there's, the late 1970s, which, I was there for about a day and a half. The late 1970s were this remarkable period of Congress reacting to the perceived and in some cases perhaps real excesses of the post-World War II presidents by really trying to reassert itself. It is, to this day, the most recent period of dramatic, significant efforts by Congress to assert its institutional authority at the expense of the executive branch. And that really does persist all the way up to really September 11th. Then there's September 11th. And, I think everyone has different sort of reactions to September 11th. But from a legal and constitutional perspective, one of the really remarkable and important and I think controversial shifts in U.S. law and U.S. legal conversations after and in response to the September 11th attacks is far more aggressive assertions of that third type of executive power, of preclusive constitutional power by the president than we had ever seen before. So with like 2 exceptions from the Nixon administration, and there really were just 2, we really had not seen presidents argue with any kind of regularity that statutes limiting their power were unconstitutional until some of the post 9/11 Bush administration cases. This was the argument, for example, that the Justice Department's Office of Legal Counsel made in its controversial memos published in the summer of leaked in the summer of 2004 about the U.S. Detainee interrogation program, including memos suggesting that it wouldn't be unlawful for the president to torture detainees, notwithstanding an express statute prohibiting it. This was the arguments that we saw in the context of the military commissions that President George W. Bush stood up for enemy combatants being held at Guantanamo Bay. And this was actually the argument we saw with regard to the first leaks of some of the surveillance programs that the federal government, especially the National Security Agency, were engaging and conducting in the latter part of the aughts in 2006, 2007, 2008. We saw over and over again arguments that, in fact, the president couldn't be restrained by statutes, including some of the statutes Congress enacted in the 1970s to limit the presidency. Now, the important point for present purposes is that those arguments never really were resolved. That very few of those issues ended up in the federal courts, and none of them produced any kind of up or down Supreme Court decision specifically on the question of whether the president could act in the face of statutory restrictions. If anything, the closest the Supreme Court came during that period to saying anything on the subject was in a 2006 case called Hamdan versus Rumsfeld, where the court seemed to pour some cold water on President Bush's ability to depart from statutes when it came to military commission trials. But even that was equivocal. And I want to suggest that persisted. This pattern persisted with presidents sort of tentatively being willing to invoke claims of preclusive power. Past the Bush administration, we saw some of those from the Obama administration. We saw some during the first Trump administration. We even saw some during the Biden administration. But what I think really stands out about the last year plus is that we are now seeing more of these arguments in more contexts and with broader consequences than I think we've seen from any prior president. That the second Trump administration especially has been very aggressive in asserting this especially broad claim of executive power that the president can act in defiance of statutes. And I mentioned these already, but just to come back to perhaps the three most visible examples. So the first is, again, in the context of appropriations, where President Trump has claimed the authority unilaterally to refuse to spend an awful lot of money that Congress has directed the federal government to spend. And there are variations on this theme. The Trump administration has cut in half or in more than half a bunch of federal agencies in ways that have stopped them from spending their money the way that Congress had directed. And these appropriations claims are preclusive claims because many of these actions are at least seemingly in violation of the Impoundment Control Act of 1974. And the Trump administration's position is, doesn't matter, that statute's unconstitutional. That issue has not also been fully litigated in court yet, but it's on the radar screen. A second example I mentioned is the firing of heads of executive branch agencies. President Trump has made no secret out of his desire to remove anyone from agencies who isn't willing to do his bidding. This has meant the firing of members of the National Labor Relations Board, the Merit Systems Protection Board, the Consumer Product Safety Commission, and even an attempt to fire a member of the Federal Reserve Board of Governors, although that one at least was not successful. That too is coming in the face of statutes that say cause is required before these folks could be removed. And the administration's argument is that those statutes are all unconstitutional. Finally, and this one's a little bit more in the weeds, but the military operation that the United States conducted in early January to arrest Nicolas Maduro was also based on this kind of claim. So it was not what we've seen from other presidents in recent years, an argument that the military force was necessary as a form of self-defense. Rather, the legal argument that we've heard most directly from Secretary of State Marco Rubio is that the reason why we sent troops into Venezuela was because we sent FBI agents into Venezuela to arrest President Maduro. And the troops were there to protect the FBI agents, which is a pretty clever bootstrap, if you ask me. The reason why this falls into this third category is because the United States is not just a party to the UN Charter. We have ratified the UN Charter. It is not just some hortatory international law proclamation. It is the law of the United States. And yet, violating Venezuela's sovereignty without any of the exceptions provided in the UN Charter is a violation of the UN Charter and therefore of US law. And we did it anyway because the Trump administration believes that Article 2 allows the president to violate international law and thus US law in those circumstances. Again, folks are going to have different views about the policy wisdom of each of these moves. What I think can't be denied is that these are pretty significant assertions of executive power, in some respects, either different in degree or different in kind from assertions that we've seen from prior presidents. All right, so that's sort of the big historical evolution. I want to spend sort of the last 10 minutes of my presentation talking briefly about the guardrails. Right, our topic for this evening is not just executive power, it's also, are the guardrails on executive power working? So let's talk about what those guardrails are. So historically, I want to suggest that there have been at least 4 sets of guardrails. The first and perhaps the hardest to visualize have been the guardrails historically that presidents of both parties have confronted from their own executive branch. That is to say, right, that there has been sort of checks and balances within the executive branch that have reined in, I think, some of the more aggressive impulses of presidents of both parties going back for as long as there has been an executive branch. Lawyers in the Justice Department, at least historically, are there not to provide rationalizations for everything the president wants to do. They're there to suggest what can and can't be done within the bounds of the law. Cabinet secretaries, at least in some respects, are supposed to have a modicum of responsibility, not just for carrying the president's agenda into effect, but for ensuring that their agencies are able to most effectively discharge their duties. Inspectors general in executive branch agencies have historically been a very important check on abuses, whether at the policy level or at the individual level within the executive branch. And so that's one chunk of guardrails historically that has been at least moderately effective. And I think it's safe to say those guardrails have largely been dismantled by the current administration. Again, maybe we, can defend that as a policy matter, maybe not, but it's very hard to argue that those guardrails still exist, whether or not you think they ought to. President Trump has fired a number of inspectors general without replacing them. President Trump has fired tons of officers and employees who either didn't agree with his agenda or who had taken actions that he disagreed with in prior administrations. And President Trump, I think, has made it abundantly clear that he expects those working for him in the executive branch to do what he asked them to do and to worry about the law second. A very good example of this, on his very first day in office, President Trump signed the executive order respecting TikTok, which not only instructed the Attorney General to decline to enforce the ban on TikTok for at least 75 days, and that got renewed, but actually which instructed the Attorney General to write letters to any electronic communications provider who asked for it, saying that what they were doing by supporting TikTok was not actually illegal. In other words, we're not going to enforce the law, and we're going to write a get out of jail free letter when what they're doing clearly violates the law. That is the mentality, I think, that has persisted in this executive branch, and it means, for better or for worse, that those internal checks that historically had at least some efficacy are now basically entirely gone. Okay, the second set of checks historically has been this remarkable body of government that we sometimes call the United States Congress. And, Congress, I think, historically has exerted checks and guardrails on the executive branch in a lot of different ways. But it might be most helpful to break these down into formal checks and informal checks. So obviously, the most formal check is the impeachment power. Congress has the literal power to impeach and remove the president. But other formal checks include the spending power, which is a power Congress has wielded historically, even when it has had trouble leveraging other authorities against the executive branch, both in deciding what the government should have the money to spend and in deciding what the government should not be able to spend on. Those formal powers, I think, have also proven somewhat less potent during the second Trump administration. The impeachment power, of course, because we've reached a point where impeachment really is unavailable almost entirely without a meaningful defection from the president's own party. That hasn't happened. And on the appropriations fund, I mean, we have seen a remarkable, I think, shift in power and control over the power of the purse from Congress to the executive. Just to give you one illustration of this, Tom Cole is the Republican congressman from Oklahoma who happens to be the chair of the House Appropriations Committee. And last year, when some of the first aggressive claims by the Trump administration were being made that the president did not have to spend money that Congress had appropriated, Chairman Cole's response was, that's okay, appropriations aren't really laws, they're just suggestions. That is a pretty radical position for the chairman of the House Appropriations Committee to take about congressional appropriations, and if nothing else, it testifies to how those checks, too, have been less efficacious. There's also the informal ways Congress historically has checked the executive, the oversight function, Congress using its power to investigate, to hold hearings, to otherwise subpoena the executive branch. I think it shouldn't surprise folks who are with us tonight that Congress has not exercised that authority very aggressively at all lately. Now, it's worth, I think, underscoring some of this was already trending in this direction. I think Congress has become largely indolent for a long time that precedes the current administration. But I think we're seeing accelerations and exacerbations of these trends in ways that I think are in the long term not healthy for the separation of powers. There's a great old story about Speaker of the House Sam Rayburn that Aaron Sorkin appropriated in an episode of The West Wing. So there's a freshman Democrat who comes to Washington who finds Speaker Rayburn and says, Mr. Speaker, where are the Republicans? I want to meet the enemy. And Rayburn puts his arm around the freshman Democrat and says, son, the Republicans aren't the enemy. They're the opposition. The Senate, now that's the enemy. We don't think like that anymore. We don't talk like that anymore. And I think that's part of why the congressional guardrails have also increasingly across multiple administrations proven ineffective. That brings us to guardrail number 3. And guardrail number 3 is the courts. So I think one of the remarkable features of not just the Trump administration, but really the last few administrations, is how much more we have all come to expect, for better or for worse, disputes over executive power and disputes over presidential policies to make their way into the judiciary, and how much more we have come to expect that these disputes will move quickly, that they will lead to final decisions from the Supreme Court. Indeed, the Supreme Court will step in to all of these cases. That is new. It was not the case as recently as 30 or 40 years ago that every big policy question in the country ended up in the Supreme Court. And we can talk about some of the sort of longer term reasons why that's happened in the Q&A if folks are interested. What that has meant is that we have seen an increasing number of confrontations between presidents of both parties and the courts. And this has, I think, in turn, made the Supreme Court even more of a lightning rod than it had been previously, where the court is deciding more and more of these cases, where it's being asked to basically pick sides when it comes to claims of presidential power. And so with that, in that respect, I think the courts have actually probably done the most of any of these institutions to live up to their at least theoretically intended constitutional guardrails. The tricky part is that one of the real, I think, interesting developments of the last year has been the volume, that the Trump administration has been doing so many different things, affecting so many different people across such a broad axis, that there's a degree to which the courts actually have been perhaps overloaded with executive power cases to a degree we've never seen before. And let me just give you one data point on this. So in the Supreme Court specifically, there's a particular type of relief called emergency relief, which is early in a case when a party that loses in a lower court asks the Supreme Court to nevertheless give them what they want temporarily while the case works its way all the way back to the Supreme Court. Historically, this was rare, and it was especially rare when requested by the executive branch. So during the George W. Bush and Barack Obama administrations, two pretty different two-term presidencies, the federal government asked for this special kind of extraordinary relief from the Supreme Court a grand total of 8 times. That's once every other year, 8 requests in 16 years. During the first Trump administration, this really ratcheted up to 41 of those requests in 4 years. So that's a really big increase, but still less than once a month. This slowed down a bit during the Biden administration. There were 19 of these during the Biden administration. In the first year of the second Trump administration, the Justice Department asked for this kind of relief 32 different times. So even compared to the first Trump administration, that's a huge uptick. Compared to the Biden and Obama administrations, it is a 64-fold increase in how often the Justice Department is going to the Supreme Court early in the case for this kind of relief. That's especially striking when you consider that the Supreme Court is only deciding these days 55 to 60 cases a year. So now, like upwards of half of its docket has become these high-profile executive power cases about the Trump administration. So I think part of the story here is that the courts as a guardrail have worked pretty well, but that they're under more pressure than we've ever seen before. One font of that pressure is the volume. One font of that pressure is the lack of support from other branches. In the past, when there have been confrontations between the executive and the courts, Congress has had some role to play. Now we have Congress sitting on the sidelines. And the last piece of this, though, is I also think we are seeing more criticism and more efforts to attack the courts by the current executive branch than we've seen certainly in my lifetime. And frankly, I'm not familiar with ones from before my lifetime. Just to give you a couple of examples, President Trump has called specifically for the impeachment of a couple of federal judges who have ruled against him in some high-profile cases. Attorney General Bondi filed a misconduct complaint against a federal judge, largely because of his conduct in a case in which he ruled against the Trump administration. It's almost unheard of for the Justice Department to file that kind of complaint. The Deputy Attorney General, Todd Blanche, told the Federal Society National Lawyers Convention in November that the Justice Department is, quote, at war, unquote, with the federal judiciary. Deputy White House Chief of Staff Stephen Miller has a tendency of referring to any decision ruling against the Trump administration as part of a judicial insurrection. And these attacks, in turn, have precipitated an unprecedented number of threats against federal judges. Even according to the U.S. Marshals Service, those numbers are way up. Threats to their physical safety, threats to their well-being, you name it. So I think the courts are probably doing their best, but I don't know that the courts are really well set up to go it alone. And I think that at least most of what's been happening to this point has been a rear guard action that may not in the long term be sustainable. After all, courts can only enforce their decisions with the help of the executive branch. And why is the executive branch going to comply with judicial decisions it doesn't like? Usually it's because of the political pushback that would result if it didn't. But I think the politics have gotten very different on this question in the last few years. All right, so that brings me to my very, very last point. And then, Liz, I'd love to give you the floor. The last guardrail, and I think this is the one we don't talk about enough, is us. And us, I mean, we the people, we the voters, we who get to decide who to send back to Congress as early as this November. And that guardrail is critically important because it is electoral mandates. It is the ability to elect a brand new House. It is the ability to elect 1/3 of the Senate. That gives us a very important voice and a critical role in checking the executive. A second-term president who, won't run and can't run for a third term, I assume, is presumably not worried about having to go to the voters again in his career, but Congress is. And so I think part of why we've seen just in the last few weeks a bit of a shift in the tenor of the political conversation in Washington on things like, for example, DHS funding is because folks are now thinking about the November elections and are thinking about the sort of the specter of President Trump's actions provoking the kind of backlash that might have significant results at the polls. That's not me saying that folks should vote any one way or the other. It's me saying voting is a check, and it has been a guardrail on the executive historically. And I think it will continue to be one as long as we ensure that everyone has the ability to vote, which is one of the things that I spend the most time thinking about these days. So on the broad question, are constitutional guardrails working? I guess my short answer is less than they have at any other point in American history, which ought to really alarm us. But I think they're still working more than the most, I think, extreme critics would perhaps have us believe. And so the real issue and the real, I think, goal for all of us should be to make sure those guardrails are reinforced as we head into the final 3 years of the Trump administration, as we head into whatever is to come thereafter. So thank you so much for your attention, and I really look forward to our conversation and your questions.
Thanks so much, Professor Vladeck, for your incredibly interesting talk. Really important points. And I'll be the first to ask the first question of the evening. I'll ask our audience again to please post your questions in the Q&A. But to get it started, can you please discuss a bit about the difference between administrative state, as some people call it, and this concept of executive power, reality of executive power?
Sure. So the administrative state, as most people use the term, is basically the apparatus that exercises the power that we talked about in our first bucket, the first kind of power, delegated statutory power. And so this concept really dates all the way back to the late 19th century, where the federal government really explodes in size during the Civil War, partly as a result of the Civil War, and actually partly not. And with this massive bureaucracy comes the need to have some bureaucratic control. And so administrative law is the law that emerges from Congress giving these agencies the power to act on their own. Congress gets to a point where it realizes we can't legislate on everything. We can't, decide what the specific meat inspection standard should be for the Department of Agriculture. We can't decide what the specific pollution limits should be for power plants, right? Like we want to have agencies that can basically take relatively broad delegations from us and operationalize them. And, Liz, one of the interesting points here is that part of that's a reflection of how small Congress is, right? We have a 435 seat House of Representatives. I think it might surprise folks to learn that number hasn't changed since 1911, right? That, the sort of the proportionality of representation has become very skewed. Mind you, in ways that probably benefit Montana, but in ways that I think are, at least to some degree, responsible for the rise of the administrative state, because Congress lacks the capacity to legislate on all of these subjects. So instead, Congress stands up agencies, and Congress gives agencies power, and the agencies are run by folks who are themselves appointed by the president. And so the idea is that the president is having some say, maybe now full say, over what these agencies are doing. The concern that had arisen, and that I think was especially vocal coming from the more conservative part of the political spectrum, was that these agencies were actually not democratically accountable, was that you had, faceless bureaucrats setting these policies. And I think there's more than nothing, Liz, to that charge. But of course, part of why these agencies were given a modicum of independence was because of Congress's belief that they'd be able to do their jobs better if they weren't subject to the president's daily whim. Think about something like the Bureau of Labor Statistics. Right? Do we want, professional statisticians giving us our labor statistics, or do we want political operatives in the White House who have lots of incentives to try to fudge that data for political purposes? And so, that was the tension, is how do we get expertise where we want it, that is at least to some degree insulated from political control, but that is still accountable. That was basically the administrative state sort of dance that we went through, really from the middle of the New Deal in the 1930s, all the way to about maybe 10 years ago. And it's only in the last 10 years, especially with the Supreme Court we currently have, since the resignation of Justice Kennedy in 2018, that we've seen the Supreme Court move very aggressively away from that conception of the administrative state and toward a conception of the administrative state where, yes, agencies can have all this power as long as they are directly accountable to the president, right? And as long as they are able to sort of do nothing without the president say so, and if the president doesn't like what they're doing, he can fire all of them. That's the accommodation the current Supreme Court has made, which has sort of blurred the distinction between the administrative state and executive power. And I guess I just want to suggest that I don't think it is as obvious as you might often read in the media that that is necessarily a good thing.
Interesting, very interesting. Thank you for explaining that. To switch over to back on a bit on the court side and some important points you made about the Supreme Court and the emergency relief decisions. One question we have from our audience: how does the judicial branch reel back in emergency relief decisions that it has allowed when it eventually rules fully on a case?
Yep.
And then the second part of the question, if I might, will the Supreme Court even get back to these cases in many executive branch cases?
Those questions are super related, so I'm glad that you tied them together. The short answer is it really depends on the case. And so, imagine, for example, a federal policy that is blocked by a federal district court, by the trial court. And the Supreme Court says, no, we're going to let the policy go into effect for now. But then the case comes back in 2 years. Liz, we have examples of the Supreme Court going one way at the emergency application stage early in the case, and then going the other way on the merits, right? Where, after time, percolation, briefing, the court changed its mind and either let the thing happen or block the thing that it previously let happen. So it is very possible that could happen. It is very possible that, even all these rulings we saw from the Supreme Court over the last year that have mostly sided with the Trump administration might not be telling us that the Trump administration is going to win on the merits. The problem, and the second question gets this, the problem is that some of these cases don't come back. So, for example, right, when the Supreme Court allows the Trump administration to remove hundreds of thousands of immigrants, right? They're not going to come, they're not filing new appeals. They're not going to continue pursuing this litigation from whatever country they're removed to. When the Supreme Court allowed the Trump administration to basically cut the Department of Education in half, right? The folks who, were fired, lost their jobs, got new jobs, maybe even moved, right? They're not coming back. And so part of the problem is that it's not just that these cases may not come back, it's that the consequences of many of these rulings may be permanent. This is why, I've written probably more than any human ever should have about all of these rulings on emergency applications. One of the things that I think is really complicated about them is that their volume and the policies we're talking about mean that even what the court might view as a temporary interim ruling, Liz, could have massive permanent effects.
No, that's a great point. And this next question sort of gets to that. Is there a way for the judiciary to protect itself from being overwhelmed by all of this? Are there guardrails within the guardrails for that?
It is tough. I don't know how many folks saw the news story last week about the chief federal district judge in Minneapolis, a judge by the name of Patrick Schultz, who is no bleeding heart. Chief Judge Schultz, clerked for Scalia twice, right? And Chief Judge Schultz raised this very serious concern that ICE is defying, release orders. For I think he had more than 90 examples of cases where judges in Minnesota had ordered the release of immigration detainees, and ICE had, Liz, not complied. Right? There's a volume problem here. Just this last week as well, we saw a government lawyer in one of those Minneapolis cases basically have a breakdown in the middle of the argument because she had been assigned 88 of these cases. And so, there really is, I think, a growing concern that the volume itself is a problem. I will say, I think the federal courts have been remarkably nimble and flexible, but it's a zero-sum game, Liz, where for all of the resources that federal judges across the country are devoting to these cases, they're not devoting those resources to other cases. And so what we might think of as like the ordinary litigation has slowed to a crawl in many of these jurisdictions, in Minnesota, in DC, in Boston, for example. And that may not have sort of structural nationwide effects, Liz, but if you're someone who has a very important case for your business or for your family that's just not about some nationwide policy, those effects could be pretty substantial. So I don't think it's having like a qualitative effect on the federal courts yet. I do think it is having a practical and quantitative effect that's probably dragging a bunch of other stuff to a halt.
Thank you. And shifting to another question, we've had two questions here and about the state. So one question and related, is there anything in the Constitution or in law which would prohibit states from running initiatives to, for example, impeach the president? And I know you recently in the New York Times also wrote about what state guardrails are there on, for example, what's happening in with federal law enforcement against and violence in Minnesota. So the state power part of this.
State power is such a great, it's a great question. It's actually a series of questions, right? So one of the real geniuses of our Constitution is federalism, and it's the division of power between the federal government and the states. Just to take one super important, just to go back to my last point, elections, right? The fact that even federal elections are generally run by states, I think is actually an enormously important protection against, Liz, federal interference, right, in the electoral process, as I think we might be seeing in real time. So the problem is that the flip side is also true, which is states can themselves jeopardize our constitutional system. That is, I think, a plausible account of the Civil War. It is I think, plausible account of state refusals to comply with the Supreme Court's desegregation orders in the 1950s and 1960s. So the question is, how do you strike that balance? How do you split the difference? And I think the best that can be said, I think the Supreme Court has done a pretty good job historically of drawing this line, is that states can have remedies against the federal government. So when federal law can maybe prosecute them if they really were not acting reasonably. When the federal government has gone too far, right? States can refuse to. States are not required, for example, to enforce federal law, but states can't override the federal government, and so we don't let the states impeach. We don't let the states have laws that supersede federal law, right? It's all about the provision of Article 6 of the Constitution called the Supremacy Clause, and exactly how we understand where the federal government is supreme and where the states are supreme. There's no perfect answer to that, but the reality is that I think we are all at our best. Our rights are best protected when there's meaningful accountability in both directions, which is not necessarily what we're seeing right now.
Well, that's very important. Thank you so much. A historic question here. One of the early questions we had here was about, in the founding, the founders. What other, separation of power questions did they wrestle with? And some obviously in the historical record, in terms of what other guardrails, how the separation of powers were obviously supposed to work, and other remedies that were discussed at the time.
So, I think the most important thing to say about the founders, and if we mean by founders, the people who wrote the Constitution, is that perhaps the biggest thing they just failed to appreciate was the rise of the modern party system. Right. So the first party system, the Federalists and the Democratic Republicans, the Constitution, Liz, would have been written totally differently if the founders had been thinking about political parties. And the problem is that because they weren't, there are a number of structural features that presupposed, as Hamilton and Madison and Jay wrote about in the Federalist Papers, that elected officials would be statesmen. And would put their institutional responsibilities ahead of their personal picadillos and their partisan political preferences. There weren't partisan political preferences to worry about in 1787. And so I think, the reason why the original understanding of the separation of powers, I think, feels so foreign to us today is because of the party system. It's a common trope among political scientists that we live in a country right now that has the separation of parties, not the separation of powers. When one party controls both branches of Congress and the White House, there's very little institutional checking, right? Versus when it's divided, there's tons of checking, right? But it's not about institutions, it's about political goals. So I think part of the problem is that there are tons of examples from the founding of the separation of powers working in a much more institutionally dominant framework, where Congress stood up to the president and the president pushed back against Congress, even if they were all from the same party. It is really only sort of the last, Liz, 50 years that we've seen that disappear, where we no longer have conservative Democrats in Congress. We no longer have liberal Republicans in Congress. And I think that has done no favors for the separation of powers, because it basically means there's no longer value as a member of Congress in being for the institution as such. And I think it's a real obstacle to the kinds of reforms that we're going to need, not just with regard to executive power, but also with regard to the courts, where you really need folks thinking more and more about how our separation of powers is supposed to work, no matter who the president is. And I think that has really fallen out of favor because of our current political setup.
Yeah, that leads into another question here that I think really touches on that. And being obviously the Mansfield Center with the legacy of Mike Mansfield, who was dedicated to the institutions in many cases. It's a great point. One question here though is also then about the norms that you're really discussing, and the founders talked about in terms of the social contract and social responsibility. It says our society functions within the constraints not only of laws but also of norms, and one, me included, can argue that norms are more important than the laws. How does the electorate, Congress, the courts respond to the executive not only ignoring formal laws, but also the less formal norms? And I would argue that civic education, and a plug for civic education that outfits like ours does, is really important. But can you talk about that, the norms and the guardrails of norms?
Yeah, so I think that the norms piece is such an important part of the story, and I think it really goes into that first set of guardrails I was talking about, the internal checks, that there were norms of behavior that constrained prior presidents of both parties that really have gone out the window. I guess the real lesson to me, and I think this was a lesson from long before last January, is that norms are only as good as our politics. And if our politics are going to be entirely sort of beholden to partisanship, then we should stop thinking that norms are going to be effective, because norms are not going to constrain. The way norms constrain is when there are cross ideological consequences for breaking them. And if we live in a moment in which, no Republican's ever going to be mad at a Republican president who broke a norm, then norms aren't going to do anything anymore. I think the real lesson, Liz, is that we should be codifying more of our norms. That, just because it was a norm doesn't mean Congress shouldn't make it into a law. And I mentioned, I think, about 40 minutes ago now, the very robust period of legislation in the late 1970s when Congress imposed a whole slew of new statutory constraints on the executive branch. Seems to me no matter what happens in 2028, like that should be the goal for whoever's in Congress come January 2029, because, a lot of the things that we thought would constrain the president haven't constrained the president. And all the more reason then to create more robust constraints, and frankly, Liz, more robust consequences when those constraints are violated.
Yeah, thank you. Thank you for that. Yeah, I'm going to shift back to the courts. We've got a few different questions about the courts, and I think a lot of curiosity about the term, what is the shadow docket? Its impact on institutional guardrails, you've touched on it already. And then the follow-up question is, what is the import of the Chevron decision in the face of the strong assertion of preclusive executive power?
Yeah, wow. Okay, lots going on here. So the shadow docket is a term that was coined by a University of Chicago law professor named Will Bode in 2015 to describe basically everything the Supreme Court does other than the 55 to 60 decisions we get every year in the big fancy cases that get argued and that get like these 80-page opinions. That means, right, the sort of how the court decides which cases it's going to take and not take by granting or denying what's called certiorari. It includes all of these emergency requests. It includes all these other, Liz, procedural things the Supreme Court does that can actually affect us quite a lot, as we've seen over the last year. And, I wrote a book co-opting Will's title, The Shadow Docket, in 2023. So if folks want to learn more, boy, do I have a book for you. But the sort of the short version is, what's striking about the shadow docket is that the norm, we're back to norms here, for the Supreme Court is to not explain those orders, is to not give us a vote count on those orders. And, Liz, when the order is anodyne and it's just procedural, like, hey, party, you can have 30 more days, no one cares. The court didn't write an explanation. But when the order is, oh, yes, President Trump, you can remove every single transgender person from the military, maybe an explanation would help. Or you can cut the Department of Education in half. Like maybe that explanation would help. So, the shadow docket has become a lightning rod, not so much because of the politics, at least from a partisan or ideological perspective, but because the Supreme Court is doing ever more important stuff, Liz, without telling us why. And I think that raises concerns, even if you like the bottom lines of what the Supreme Court is doing, and especially if you don't. To the Chevron question, this is, without sort of spending 10 minutes doing the history of administrative law. So Chevron, very loosely described, is a 1984 Supreme Court case that stood for the proposition that agencies are entitled to deference when they're resolving ambiguities in statutes. So if you've given, the Food and Drug Administration the power to decide what makes a particular type of drug dangerous, right? The fact that a federal judge might not agree with their definition of dangerous doesn't matter. The Food and Drug Administration wins. The Supreme Court got rid of that 2 years ago, right, and ended Chevron in a case called Loper-Bright. It doesn't really undermine executive power as such. Agencies can still try to persuade judges that their interpretation is correct. Liz, what it really does is it enhances judicial power, because now the judge is allowed to second guess the agency. Right now, the judge can say, well, that's nice, FDA, but I have my own definition. And, I think it's a fair question whether we trust better the scientific experts or the technical experts to define these terms, or a single judge who was handpicked by whoever's challenging this regulation in the friendliest forum they can find in the country, whether it's Texas if it's a Democratic administration, or San Francisco if it's a Republican administration. So it's really about transferring power from these agencies to the courts in ways that I think are pretty significant, and that, again, get us back to the question of where's the balance? What should the guardrails be?
Thank you very much for that. Yes, there are so many great questions here. I wish we could ask all of them. I'm sorry that we can't. I'm going to ask the final question of our evening, if we can take 1 minute past, a couple minutes past 8 o'clock. I think this is an important one, and so I'll pitch this last one, is that I've heard mixed opinions on whether we're in a constitutional crisis. Do you think we're nearing one? And what are the indicators that we are in a constitutional crisis?
So I totally understand why people ask this question. I will confess to kind of hating it, because I'm not sure what difference it makes. If we are or are not in a constitutional crisis, we have the same problems tomorrow that we had yesterday. I think what I suspect we can probably all agree on, no matter our politics, is that we are deep, and I mean years deep, into an institutional crisis. And it's an institutional crisis that I think is largely the result of Congress stopping to do its job, of Congress no longer doing its job. And let me just take immigration as a good example. Immigration is quite obviously a huge policy lightning rod, where everyone's going to have very strong divergent views about what our immigration policies should be. Part of why presidents of both parties have been left to deal with immigration through executive orders, because Congress hasn't passed meaningful immigration reform since 1986. The Mets won the World Series. That's how long ago it was. And so I don't know that it's a constitutional crisis. It is a serious institutional crisis where we are left to have all of these confrontations between the president and the courts. And in the long term, that's not good for anybody, even if we like the short-term results, because our constitutional system, to quote James Madison in Federalist 51, is predicated on the idea that ambition must be made to counteract ambition. We have a very ambitious executive right now. We have a pretty ambitious judiciary. We have a completely feckless Congress. And, the result of that, I think, is deep instability for our separation of powers. It's enabling presidents to claim more power than they ever have before. And I think we're seeing the very real consequences in our society and on our streets of presidents who are increasingly unsubject to those checks. I don't think that's a constitutional crisis, Liz. I think the Constitution actually is still kind of working. But I also think that, we can have serious problems long before we get to the Constitution, and long before we get to a crisis, right? If, as President Lincoln said early in the Civil War, are all the laws but one to go unexecuted, and the Constitution itself to go to pieces, right? The problem here is deep, it's structural. It may not be a violation of the Constitution, but man, it is certainly a violation of its spirit.
Thank you for framing that. I think that is a great way to think of it. And thank you so much, Professor Vladeck, for such a tremendous and timely conversation. This has just been a really interesting discussion. And to our audience for joining us and caring about these issues. Please join us again on February 24th for our next dialogue. We'll actually host Robert Doerr, the president of the American Enterprise Institute. You can register for that lecture on our website as subsequent ones. Again, thank you so much, Professor Vladeck, for joining us here in Montana and the places our audience may be this evening. Please have a good evening.
Thanks, Liz. Thanks, everybody. And if you found this interesting, I hope you'll check out my newsletter.
Thank you.
Thanks, everybody.